The Center for Educational Media and the College of Education at Middle Tennessee State University are proud to offer professional development to K-12 educators in Tennessee through our online video library. These videos are aligned with standards set by the Tennessee Department of Education. For more professional development videos, check out our website at www.mtsu.edu/CEM.
Our next presenter is attorney Marjorie Bristol. Attorney Bristol will be speaking this afternoon about the important legalities in the world of special education. It's important to note she is also the parent of children with disabilities. Thank you for your time today and welcome.
I am so glad to be here, Dr. Pence. Thank you for asking me to come and talk to everybody. I am super excited. Dr. Pence has had me come talk to her class before. I enjoy talking about what I do because I'm passionate about what I do. I want to talk a little bit about how I work as an attorney representing children and families within the special education arena. And I want to put a little caveat on that because I am very different than a lot of attorneys who represent families and children in this area. My approach is very collaborative. If you as a special education teacher see me walk into an IEP meeting, just know that I'm there to problem solve. I'm not there to blame. I'm going to try to figure out how we got where we are, but I'm not, blaming doesn't do a whole lot. So I don't spend a lot of time there. And I do that because I have, as Dr. Pence said, I have children with special needs. I've been a parent in an IEP meeting. I worked for the Department of Children's Services for many years, and the Department of Children's Services has its own school system. So I represented that school system. And I've just been kind of all over the place within the system of special education. So it is something that is near and dear to my heart. I am I consider myself a data geek. I do love some data. And I like to, as I said, I believe in the collaborative process of the multidisciplinary team. So having said that, there are attorneys who handle the situation much differently. A lot of them are more combative, I guess would be a good word for it, in an IEP meeting, but I don't find that that's as effective for my families that I represent. So we're going to go through this. I'm going to go through the law fairly quickly just so that we have an overview. I'm going to give you some practical situations that I have found myself in representing children. And then hopefully we'll have lots and lots and lots of questions because I'm here to, stump an attorney if you want to. Okay, so here we have just the overarching law, the Individuals with Disabilities Education Act, the IDEA. When I represent parents, I have to talk to them about the alphabet soup that goes with the law, your IDEA, your FAPE, your FBAs, and your BIPs, and it is a lot for parents. And so I consider myself first and foremost an educator for my parents that I represent so that they understand what's going on. Because so often when I'm in IEP meetings, teachers do a great job of trying to make sure that, teachers and administrators try to make sure that the parents understand what's going on, but sometimes they're really just lost in the weeds as far as what is the practical application of what we're talking about. Developing and implementing the IEP. As I said, I believe in that collaborative process. The law requires that certain people be present at the IEP meeting. And a lot of, especially general ed teachers, don't understand why they keep having to go to these IEP meetings. And it's because they are required to be there under the law. In fact, there's case law that says that it is a clear violation of the law if there's an IEP meeting and there is no gen ed teacher there. So the gen ed teacher is required to be there, special ed teacher, the LEA representative, and that LEA representative has to have the authority to make funding decisions. So it doesn't always have to be a principal or somebody like that, that person does have to have the ability to make funding decisions. The parent, there is a ton of case law out there about school districts who have excluded the parents from meetings. And I realize that scheduling meetings when parents work is difficult, especially when the school day goes usually until 2 or 3 in the afternoon and parents don't get off from work until 5 o'clock. But if you don't make that meeting time, to where it is reasonably attainable for the parent, you're going to have a problem if you have IEP meetings without parents. Other members, the interpreter of evaluations, any related services, and any other person that the parents want to bring, or the LEA, somebody who has special knowledge about the child. Okay. So the IEP has to have certain things in it: present levels, goals and objectives, the progress monitoring, how we're going to decide how we're doing on this goal, special education related services, supplementary aids and services, time, place, and duration of services, the LRE statement, accommodations, the transition plan. So for students, for teenagers, I will say this about what I'm seeing in the field over the past 2 years. I am really impressed that for the most part, because I deal with school systems all over the state, and there are a lot more transition services available in the past couple of years for these kiddos than there were even 5 years ago. So I'm super excited about the opportunity, because that was always kind of one of my soapboxes that I got up on, is that we're not really preparing these kids to transition to adulthood. So there we go. All right. Now, the goals in the IEP need to be SMART, and that means that they need to be specific, measurable, attainable, relevant, and time-bound. Okay? So nothing drives me crazier when I'm reviewing an IEP to look at a goal that is so vague that there's no way that you can tell whether or not the student is making progress on that goal or not. There are not adequate measures included in that to know whether or not the student is making progress on that goal. And over the past probably 5 to 7 years, I've seen a big improvement on that in the way that special education teachers are writing their goals. The area where I continue to see a little bit of problem is that I don't always think that those goals are attainable within a 12-month period. And I'm constantly in meetings saying, I think we need to break this down, take a little bit smaller bite out of this apple so that we can make sure that it's attainable. Because I would rather us come back in 6 months and say, oh, well, Marjorie, you were wrong. It was attainable. And, now we've completed that goal. We need to make a new one. And I would rather meet again and develop a new goal because the kiddo has achieved it. Relevant. This is where that goal has to relate back to those present levels. Those present levels are going to drive the goals. What does that child need to work on based on their strengths and needs within the classroom setting? And time bound. Usually those goals are going to be over the course of the year-long IEP, but I really appreciate it when special ed teachers have short-term goals and long-term goals, and have those goals set to be completed within the first semester or the first quarter. I really appreciate that. I think a lot of time and thought goes into that, and I think that serves our children really well. Things that make me crazy with IEPs. Goals that stay the same for multiple years. If the child is not achieving that goal within a year, then the goal is bad and it needs to be rewritten. We need to break it down. We need to figure out what we need to do to take smaller steps. That goal may be the ultimate place where we want to see the child move to, but we need to break it down into smaller bites. goals that don't relate to the present levels, and goals that only the author can understand and that they're so vague that they can't be measured. Other things that I'm going to immediately, jump on: no start date, no end date. You change services without a meeting. Sorry, my dog decided to come say hello. And that they're not specific enough. Okay, free and appropriate public education, or FAPE. The free and public education portion of this is usually, we don't have any argument within the legal field about that. Where we argue a lot is what is appropriate and what is not. So the standard really changed with Andrew F., which is a United States Supreme Court case that said that we're basically looking at the child where they are, and that goal has to be ambitious enough in light of the circumstances of that child so that we can see growth, as Dr. Tucker was just talking about. It is really looking at that growth aspect. What are we doing to make sure we're targeting the right areas and we're making it achievable for that child and making a meaningful impact on that child's life by those goals? So again, the appropriate to the child's circumstances, what does that mean for each child? These are individualized education plans. So they're going to be different for every child. Nothing drives me crazier. I should have put this in the things that drive me crazy about IEPs, but nothing drives me crazier than a cookie cutter IEP. If you're doing the same IEP for more than one student, then you're really not looking at that student and you're not individualizing it enough, in my opinion. So we just need to look at those PLEPs, look at where that child's needs are, because every child's needs are different. All of those social emotional deficits, medical conditions, what is appropriate in light of the totality of the circumstances surrounding that individual child. All right, now some real world scenarios. And this first scenario, some of my other scenarios are kind of hybrids of some of the kiddos that I've worked with over the years. This one is absolutely one child, and I have permission from that child's mother to talk about this child. But a child with autism, he started out in kindergarten having a lot of behavior issues in the kindergarten classroom, restraints, elopements. They quickly moved him to a behavior intervention classroom. He then changed school districts. The school district that he moved to didn't have a behavior intervention classroom for elementary school students. So they created one, but he was the only child in that classroom. There was a teacher and an aide and one child. When I was contacted by the mother, had in the previous month had 127 restraints in 1 month. They had done an FBA, they had done a behavior intervention plan. So I sat down, I looked at it. They were restraining this child for property destruction. They were restraining the child for failure to comply with their directives. They were isolating the child whenever he was just like laying in the floor and refusing to sit in his chair. And so when I got involved, I told the attorney on the other side, I said, because I had filed due process, we were in the process of moving through the due process litigation. And I said, I want an email every time there is a restraint at school. I want the documentation sent to me immediately, please. And so they would send me while we're going through due process every day. There were 3 or 4 more restraints, and I would send them back an email about what was wrong according to the statute for the restraints. Because as you can see, the restraint law in Tennessee says that you can only restrain or isolate a child in emergency situations. And to me, that means, and I believe that most other attorneys would agree with me, is that it means that the child has to be a danger to himself or others. I say, what does that mean? If a child is standing there with a pair of scissors trying to stab someone, that's an emergency situation, and you probably want to restrain the child. If the child's going to be running out into traffic, you want to restrain the child and have them not run into traffic. And when I talk to parents about restraints, a lot of them are immediately like, oh, I don't want the school system restraining my child. I said, yes, you do. Yes, you do. In emergency situations, you want the school system to put their hands on your child to protect your child. And this is one place where I think a lot of teachers get a lot of heartburn about having to use restraint, because there is so much, am I going to get in trouble if I put my hands on the child? It's a much different time frame than when I was in school, and there was still a lot of corporal punishment going on when I was in school. But I understand why that heartburn is there. But what happens with children, especially with autism, is that, this child could have been de-escalated if you just didn't put your hands on him. We worked on that. Eventually, the school system volunteered to pay for private school. I'm not a big proponent of private schools. I have a lot of parents who call me and want me to get the school system to pay for private school. And sometimes it is warranted and sometimes it is not. But this particular private school was just it was a small setting, but there were other children there. That positive peer pressure of having other children who would be watching this student behave in a way that required restraint was a positive force in him not behaving that way. Once he transitioned to the school, he went from having 127 restraints in a month to where over the course of 2 years, he had 2 restraints. So, and now he's in the 7th grade, and for the first time since kindergarten, he's fully in the gen ed setting 100% of the time. So, I run into a lot of really kind of difficult cases where we don't know exactly what's going on with the kid. And I value psychological testing. When you have a child who has, an average IQ, but is still struggling to read, all of the good, reading interventions are just not making a whole lot of progress. I am astonished at the number of times when I go in and I'm like, okay, have we done any language testing? Because especially once you get into middle school or early high school, if kids are having trouble, especially with reading comprehension, it is often a language issue. They do not have that non-literal language, being able to infer what is happening next. And problems just in general with fluid concepts as opposed to concrete concepts. So that language testing is invaluable to me in being able to kind of pinpoint some of those things that don't show up on the IQ testing. Of course, on the IQ testing, I love to look at that processing speed, that working memory, things like that can also impair reading comprehension. Oh, and trauma. Trauma looks so different. I don't know how many kiddos right now that I have that have suffered severe trauma, and their IQ is average to above average, but their functioning and their adaptive skills are so much lower than you would expect. And it's because of that trauma. I mean, and they almost look like a kiddo with autism, that developmental delay piece, because of the trauma. I mean, it is amazing how much trauma can impact their functioning level. All right. I skipped over it, but I'll tell you, I didn't mean to go this far, but had a kiddo in the CDC class in high school. He was moving from 8th grade to his freshman year, and the CDC was an appropriate classroom for him. He had autism. He needed those life skills. It was a great classroom for him. He was thriving in the classroom. His teachers were great, but the high school had all of their CDC kiddos for their electives do visual arts. And this kiddo loved to sing, and he wanted to do choir. And the school said, no, he can't do choir. And I said, why not? Well, all the other kids are going to art. I'm like, yeah, but why can't he go to choir? And so we had to have a meeting, and we had to get lawyers involved. And eventually, he went to choir, and they sent an aide with him, and it all worked out. So, all right, that brings us to our next thing. Things you probably, if you're a special ed teacher or a gen ed teacher or an administrator, things you probably don't want to say in an IEP meeting. All right, things like all the other kids are going to art class, so he has to go to art. That's number one. Don't say that in an IEP meeting. All right, we don't do more than 10 minutes of speech or OT or PT or any related service for a week for first graders or kindergartners or whatever. These are individualized education plans. You have to decide what that child needs. Okay. We only do FBAs for assaultive behaviors and elopements, because if I have a kiddo with ADHD and they're not on task, if they're balking at doing non-preferred tasks, I'm going to ask for an FBA to see what we can do to increase the amount of time on task and increase the participation in non-preferred tasks. Okay, if we do this, whatever this is, substitute, let them do X, Y, or Z, then we will have to do that for all students. That is, I get that a lot from administrators who, I always attribute things like this to a lack of information about what is required for special ed students rather than any malicious intent. Unless I'm shown otherwise, because I have been shown otherwise on occasion, but very rarely. And I forgot to mention, my sister is a special ed teacher, so I am constantly calling her going, how should I approach this? Because I don't think this team gets what they're supposed to be doing. And, but administrators, especially, sometimes gen ed teachers, especially with things like classroom rules about recess. If kids don't have their work finished, there are still schools out there that will take away recess. And if you have a kiddo who has additional time as an accommodation on their IEP or their 504 even, then, in my opinion, you can't take away their recess. Okay. We don't need to include that accommodation in the IEP. We allow all of our students to turn in late work, or we allow all of our students to do retakes. And that's great, because I think those are great educational strategies. But if I have a specific need that I can identify for the student where it needs to be in the plan, then it needs to be in the plan, because I need to be able to hold somebody accountable if it doesn't happen, number one. And number two, if that child moves to another district where they don't do things the same way, then they need to know what this child needs in order to be successful in the educational setting. Now, this last one, I thought I almost didn't include this in there. This child requires too many supports to attend general ed classes. And I hadn't heard this in a long time until about 4 weeks ago. And I did have a school system where there were teachers saying, we cannot put this child in general ed classes because the child requires too many supports. That is, it shocked me, because it was kind of antiquated thinking. 20 years ago, I heard this all the time when I wanted to do, fully included into gen ed classrooms for kids. It was I was constantly fighting. But just beware, it's still out there in some districts. If you say those things, that's your lawyer's face in the meeting. All right. More. We don't have any funding to provide that service. Right now, I'm hearing a lot of, and it's a practical reality, but we can't hire any paras because there's nobody that wants to work in the school district. My answer to that is that the school district needs to pay more because, nobody wants to work in that environment for $8 an hour. But if you raised it to 20, then you might be able to get some qualified people in there. We talked about the recess. In eligibility determination, I still hear this often. There is no adverse impact because the student has good grades, so the student doesn't qualify for an IEP. That's not the standard for whether it's an adverse impact. I mean, there can be other things, social emotional impact, especially for our, ED kids, if there's a social emotional impact, or our OHI with ADHD, kids don't have to fail before they qualify for an IEP. But some school districts think that you do have to have them failing before they do. We don't need to put that in the IEP because if he needs it, I'll give it to him. And, I think that's great because most of the time, I think when teachers say this, they are genuine in their, I will help him and I will do what he needs, but it needs to be in the plan because there needs to be accountability. And then, all of our other special ed students do it this way. Well, that's that cookie cutter approach, and we don't do that for IEPs. Due process. So if you hear a lawyer say, please include in the prior written notice that the parent has requested X, Y, or Z, and the LEA has denied that request, they're setting up for due process. And when I'm in meetings with, and I have a really good working relationship. I was listening to Dr. Tucker talk about, relationships between co-teachers, and, I have excellent relationships with the attorneys who represent school districts in the state. And I'll just look at them when I say this in a meeting. And sometimes I'll even say, hey, do you want a minute to talk to your client? Almost like, are you sure you want to die on this mountain? This mistake that you're getting ready to make by not including this in the IEP or giving us this service or whatever. So just know that's kind of code. Due process, in my opinion, is not nuclear war. It's dispute resolution. When the school part of the IEP team and the parent part of the IEP team cannot agree on what should be included in the IEP or what services should be provided, then it is dispute resolution. We have a third party decide. All right. So the first part of the due process, once a complaint is filed, is you have the resolution period, which you can also forego and go straight to mediation. Because of those relationships that I have and things like the overwhelming majority of due process cases are resolved in the resolution or mediation. And the ones that do go to a full-blown hearing, that I would hope that they would be, actual issues where reasonable minds could differ. The second phase is discovery and preparation for the hearing. And that can be a really cumbersome and onerous process for anybody associated with the case to have to produce documents and emails and perhaps sit through depositions. And obviously, if you work for a school system, they have an attorney who will guide you through that process. Then you have a hearing before an administrative law judge. And I've worked with the administrative law judges at the Secretary of State's office for years. And those are the folks who hear the cases. They're also the folks who serve as mediators. And, they have very different ways that they approach these cases. And so it's always interesting to see which judge we get assigned to from my perspective. And then there's an appeal. Appeal to federal court, appeal to state court. Most appeals go to federal court. And then that can take years and years and years, which is why I try to avoid due process, because it can take years to resolve and get the child the services that they need.
Thank you, Attorney Bristol. We have learned a wealth of information. There's so much to cover here, and I know so many questions. So I'm going to throw it to Dr. Clark. If I know she's the facilitator for today's questioning. So Dr. Clark, do we have any questions for Attorney Bristol?
Yes, we have some questions. So
good. I'm glad.
First, let me just say what a valuable perspective you offer as a parent of a child with special needs and an attorney and a sister of a special ed teacher. So that's a valuable combination to give insight that others might not have. So thank you for that. Let's see, we have a question about, we've got several questions here. One other comment, as you described the IEPs, I would phrase it in terms of teachers should write an IEP as if an attorney is going to read it. And that might be a helpful way to think about it. All right, so question here. Who ultimately determines if the pieces on the IEP are reasonable? Who determines that? Is it the teacher? Is it the parent? Is it the administrator?
The IEP team decides if they're reasonable, and if they can't agree on whether or not it's reasonable, then that's when there may or may not be due process filed. And then the administrative law judge would ultimately decide.
Okay. A question, how do you one of the scenarios you talked about was referred to 127 restraints. How do you define restraint? I see the language in the Tennessee Code annotated, but how do you define restraint for teachers?
That is any time that you are physically keeping the child from being able to move you have to have your hands on them. So you're either holding them or holding their arms. If you're restricting their movement with, a lot of times when kids are trying to elope, we'll get, pads and try to, keep them from running out. And as long as they have some degree of movement, I don't consider that a restraint. But if they can't move at all, even if you're, not touching them, but using some of their those floor mats made of foam. A lot of places that I work with kids, especially with autism, use those. So I would consider that a restraint as well if they can't move.
Okay. All right. Thanks for that clarification.
And also a transport, if you're picking them up and you're moving them somewhere, that's a restraint.
Okay. All right. So we have a question here. If a parent files an administrative complaint, does it go to the state first or does it go to the school?
It goes to the state. The state processes it. They send it to the school district to respond to. And then there is an investigator assigned from the Department of Education to look into those facts and to look at the response. Parents, once the school district responds, then sometimes the investigator will have additional questions for the parents of the child. And so they'll send, hey, can you clarify this?
Okay. All right. Thank you.
Mm-hmm.
Another question here, just for some clarification. Do failing grades in all areas indicate that a student with a disability has not received free and appropriate public education?
No.
Would you elaborate on that?
Okay. So failing, I tell parents all the time, grades are one data point. That's one data point. If you have a child who is a ninth grader and is reading on a first grade level, then they may or may not be able to do the grade level content work, but that doesn't mean that we don't want them exposed to that grade level content by having them in the general education setting during that time. The student may have behavior issues that we're working on that would increase their participation in the gen ed setting. So no, failing grades does not mean that the IEP isn't working. We may be working on other things. And that's just one thing that I would look at to see if it was an appropriate IEP.
Okay, all right. Thank you for that. This is kind of a general question, but teachers, we go through our day, we say things all day, we do things all day, and we do it with, according to our second nature. But as we think about the legal implications of it, do you have any advice about, just general advice about how to begin to think about what I say, what I do, how I interact with children, that ensures that we are protecting their rights, that we are meeting legal requirements? Any general advice to teachers?
The first piece of advice that I would give is document everything, because if it's not documented, it didn't happen. And if we end up in due process and there's not documentation for service hours, or there's not documentation for a restraint, or, the antecedents to that restraint, then, I'm going to have a field day with that. So that would be my first piece of advice, is to document. The rest of what you need to do during your day is just best practice. If you have a child who is having behavior issues, then you need to get at what is causing those behavior issues. Don't be afraid to call an IEP meeting and say, hey, I really think that we need to do a functional behavioral assessment and see what we can do to help this kiddo get at these behaviors, figure out what the function of those behaviors are. What can we do to replace those behaviors with more positive behaviors? Don't be afraid to offer services to the family from, if your school has social work services, figure out what's going on with the kid. Don't be afraid to ask, for parent meetings, work together as a team and come up with a plan to help each individual child, is what I would say.
Okay, thanks. We have multiple states attending this session today, and we have some people here from South Dakota, and this next question is from New Mexico.
Okay.
Of course, as we all know, education law is unique to each state, right? Because education.
There are some federal overreaching guidelines, but then each state takes it and runs with it and kind of makes it its own.
So this comment or question has to do with the age that children are required. I believe I'm reading into this question, the age that children are required to attend IEP meetings. And I believe in New Mexico,
there is no age under Tennessee law. I think it's best practice for especially those middle schoolers. If you have a middle schooler who is mature enough to do it, I try to get them started by 7th grade anyway. But definitely by the time they are moving into high school, because once they're in high school, I really do try to get them to come to at least part of every single IEP meeting. Some kids don't want to stay for the whole thing because it's boring, and their ability to sit there for that long may not be something that they can tolerate. But I try to get them to come for at least part of it, because especially when you're dealing with high school kids, if you're going to put in accommodations and supports, then they have to buy into it, or you're just wasting your time putting them in the IEP. So I think they need to, as much as they can, have a say in what is helpful for them.
So you're saying generally 7th and 8th grade, if the child
Correct.
is ready, is developmentally.
But definitely by by ninth grade, I try to have them come to at least part of every meeting.
Okay. All right, great. So you had an interesting title earlier in your slide, things that make me crazy. So can you briefly just recap some of the things that to keep in mind? You know, so many times we do things with good intention, even that do cross the line. And so, in these things that make you crazy, can you also address that idea of unintentional crossing the line in terms of?
I think where teachers get into those things that make me crazy as far as IEPs about not relating them to CLEPs or having them be too vague is that they are just not looking at things, and it's a product of time. You know, teachers don't have enough time to be as thoughtful sometimes about these things as they would like, I'm sure. And I understand those practical realities too. But when you're looking at what you're going to do for a kiddo's IEP, if you can look at those CLEPs almost, from 10,000 feet up, separate yourself from that day to day and look at the big picture of where the child is and where we want the child to go by the end of the year. That will help guide you. And then just make sure you break them down into small enough bits.
So, Attorney Marjorie Bristol, you have really brought an important perspective to our sessions today, and perspectives that often teachers may lose sight of because we're so busy serving our children. But what you've said today, and also through the eyes of an attorney and a parent, and with with family and education, been so very invaluable. So thank you to you for your time and expertise. I know you have another commitment today, so we appreciate your time. We hope to see you again in perhaps some future sessions for the SPED Collaborative.
Thank you all for having me so much. I enjoyed it.